Welcome to our second lecture covering Chapter 6, which is, of course, the chapter in which we talk about capacity to contract. We've already discussed the definition, and we've discussed the 5 categories that can affect somebody's capacity to enter into a contract. During our first lecture, we covered the first 2 of these. We covered the need to be an adult, meaning over the age of 18 in Texas, and the need to be legally sane. Actually, this threshold's a pretty low one. Many people with significant mental illness still possess the ability to contract. During this lecture, we're going to discuss the last 3 of these requirements. So let's begin. Before we actually get too far into this, so let me go over and look for a second at our elements of a contract. Sorry about that. Took me a second to find it. Okay, so just a little refresher to see how this topic fits into the bigger picture. So we've discussed that a contract has to have 4 ingredients or elements. It must be an agreement, it must have consideration, and then the topic of this particular chapter is going to be the issue of legal capacity. We'll talk about legal object in our next chapter. We drilled down in the topic of agreement in earlier chapters and added a lot more specifics. And we discussed the topic of consideration and added a lot more specifics. And now we're ready to get into the details of legal capacity. As is true with any of these elements, if we're missing legal capacity, we don't have a contract. We might have something, it might even be legally enforceable, but we're not going to call it a contract. So we're going to be adding more granularity, more details to this particular topic in this chapter. And specifically, the details we're going to add are right here. This is pretty much what you'll be seeing in the guide for the other item, for the more information about the element of capacity. So let's continue from here. I'm going to fast forward through the minor information, and I'm going to pass forward through the insanity situation. And now we're on that third topic, the topic about needing to be sober. And of course, the issue of sobriety can arise with intoxication because of alcohol or because of some drug. This lack of sobriety can happen because of a lawful means. For example, a person is over the age of 21 and drinks alcohol, or the person has a prescription medication and takes that medication, perhaps even in the amount that the physician has prescribed, but becomes intoxicated. Or the situation can arise when a person is consuming an unlawful substance. For example, somebody under the age of 21 who consumes alcohol, or somebody of whatever age who consumes an illegal drug like marijuana or something along those lines. Cocaine, heroin, something along those lines. By the way, some people think that certain drugs are lawful in certain states, certain things that have traditionally been considered illegal. The reality is that in those states like Colorado who've made these substances legal, they may well be legal under state law, but they remain unlawful under federal law. So really they continue to be unlawful kind of in the more important sense. The reason why those particular behaviors are not being enforced as much is because the federal government has elected not to engage in significant enforcement activities, because as a general rule, we have this mainly being the subject of state courts that are involved most importantly in drug enforcement, not so much the federal government. But as I say, it remains a crime under federal law, whether or not it might be a crime under state law. But that's just not something that's really the subject of this course, but I wanted to clarify that as we're talking about the use of drugs. So really, the legality or illegality of this substance isn't what we're focusing on. We're not even so much focusing upon whether the consumption of the beverage or the drug or the substance was intentional or accidental. For the most part, that's not a huge factor in the analysis, although I'll tell you, if a person accidentally consumed the substance, perhaps something was slipped into his or her drink, or perhaps the person thought it was a non-alcoholic drink and it ended up having a significant amount of alcohol, I think in those situations, courts are more likely to not enforce a contract, because typically the idea is, hey, buddy, you chose to get drunk. You had one more drink and one more drink and one more drink, and you could feel that your judgment was being impacted. And so courts are oftentimes of the opinion that, you know what, you chose this route. You should have stopped if you didn't want to be bound by a contract. So we're going to hold you to that agreement more often than not. But there might be a little bit of give at the margins when somebody might be unintentionally intoxicated. But really, it's not so much how or why the person has gotten to this state. The more important issue is, how does this particular state affect the person? And the issue is, does this person in the state that he or she is in understand the nature of the contract? If I'm so drunk that up is down and right is left and yes is no, then I can't really be expected to enter into a contract that's meaningful. I don't have the judgment. I am the kind of the equivalent of somebody with a very, very subpar intellectual ability, or somebody who has advanced dementia or something along those lines. And so under those circumstances, how can we enforce a contract when I didn't even know I was entering into a contract? So in this situation, the person who's in this particular situation, once he or she becomes sober, can disaffirm the contract. Hey, I didn't mean to do that. I wouldn't have done that if I were sober. Or, of course, they can choose to ratify it either way. This is the same situation, the same option that we saw when we were talking about minors who attain their majority and insane people who become lucid. So that's kind of how it plays out. Now generally speaking, unlike the situation of a minor, when a person is intoxicated to the extent that they don't even know what's going on, there's going to typically be many, many indications in the circumstances that he or she is that impaired. For example, if a person doesn't have any slurred speech, is speaking standard English, who is speaking in complete sentences and is making sense and is responding appropriately, those are all really, really strong indicators that this person does understand the nature of a contract. And so again, it's going to be that standard of the fly on the wall. What would the fly on the wall have considered this circumstance to be about? If a person wasn't indicating or demonstrating any level of impairment, well, under those circumstances, probably that fly on the wall would say, well, objectively, he seems like he's just fine. There's a scene in one of the Raiders of the Lost Ark movie where the Karen Allen actress, that's her real name, but I don't know what her name is in the story. Anyway, she's got brown hair. She's drinking. She's this little bitty thing, and she's drinking with this very kind of large, tough-looking guy, and they're throwing back shots, and she really looks like she's just barely holding it together. And that's what you'd expect, because she's so tiny compared to this really, really large, bulky guy. And the last drink she downs, and she's just barely hanging on to consciousness here. And he seems completely unaffected. He drinks, and then he just seems fine, almost like it's water to him. But when he takes the last drink, he falls over, passes out, dead to the world. Sometimes I suppose that could happen, but even in the movie, this guy wasn't having lots of conversations. They didn't speak the same language. There wasn't interaction. Presumably, if they had been having a conversation, he would have demonstrated through slurred speech, through not speaking clearly or intelligently, that he, in fact, was significantly impaired. So again, we're going to use an objective standard to evaluate this. Otherwise, of course, anyone can say, oh, I was drunk. I was too drunk under those circumstances. Another important thing to keep in mind is that the standard isn't, was I tipsy or had I had a few drinks? Again, the standard is, did I understand the nature of the contract? Even if the standard is not, would I enter into that contract if I were a cold sober, no, that's not the standard. When you're intoxicated, you may well do something stupid. That's your problem. You shouldn't have been drinking. The issue is not, was it a wise thing for you to do? It was, did you understand what you were doing? Even if it was foolish, if you understood, hey, I'm entering into this contract and this is what I'm going to get out of it and this is what I'm going to have to pay and I'm on board with it, then guess what? You have an understanding about contract law and you're going to be stuck with that deal even if you end up not being happy with it over the long haul. Okay, so that's our third category, I guess you could say. Oops, here we go. So now we've talked about adults by law during our first lecture. Legal insanity also being a requirement. We covered that in our first lecture. We've covered the issue of sobriety. And of course, all the things that we talked about in terms of ratification and disaffirmance also applies to sobriety. And now we're going to talk about legal residence. Now, this one is not a common one to be an issue. Oops, here we go, went too far. Okay, so as a general rule, aliens, whether they are here with the correct documentation or not, have very few restrictions to their ability to contract. They can contract. The one exception is that when an alien is from a country that is at war with the United States, they do lack the ability to contract, but their contracts are simply voidable. So we're not talking about ET here, we're talking about aliens, human beings from other countries. And so as you can see, the vast majority of times there's really no impediment to us entering into a contract with somebody who happens to be a citizen of a different country. So let's go on to our next slide. I won't X that one out, X that out in a second. Convicted felon, this one's going to be a little bit different. These contracts are void, not voidable. So this is like the non-compos mentis that we talked about before. The reason for this is that a convicted felon who is imprisoned is being taken care of by the state or possibly the federal government. His or her needs are going to be fully met by the state or federal government. Maybe not in the way that the felon would like for them to be met, but that felon will be receiving medical care, housing, clothing, food, water, all the things that are the necessities of life. And he's not, or she's not really supposed to be participating in luxuries because, you know, he's being punished, she's being punished. So a contract that a prisoner enters into is void, not voidable, but just void. It's like it never even happened. It is unenforceable. Now, once our felon here gets out of prison, he crosses through the doors and takes his first breath of free air on the other side of the prison gates. His ability to contract immediately descends upon him. I mean, we want felons to enter into contracts because, of course, one of the big contracts we want him to enter into is we want him to go to a job. We want him to pay his way in life. We want him to support himself, and if he has a family or she has a family, we want that felon to support that family. And so we want them to enter into contracts. And we certainly recognize that they need to enter into contracts. They need to have a place to live. They need to buy food. They need to have a job. They need all of those essentials. And now the government isn't going to be providing them, so they have to be able to enter into them on their own. So once they're incarcerated, their contracts are void. Once they are released, unless there's some other problem with the contract is just going to be good old-fashioned valid. So let's consider a scenario. We have Mr. Bank Robber. We're going to call him Brad. Brad the bank robber. With a name like this, you know things aren't going to work out well for poor Brad. He was convicted of, yes, you saw it coming, bank robbery in 2000. He's scheduled for release from prison next January. Okay, getting near the end. Fortunately, he still has some of his ill-gotten gains safely tucked away, so he's a pretty clever guy. He would like to make arrangements while still in prison for his future. He's a man who likes to plan. Specifically, he would like to rent a small apartment, so that's his first goal. Buy a vintage Mercedes, that's his second goal. Look here, this is going to be maybe one he might want to consider. And number 3, arrange to have some teeth fillings replaced. The dentist in the prison maybe isn't the best. Can he contract for these services now, or must he wait until his release? Well, we can see that at least 1 and 3 seem to be necessaries. You have to have a place to live, and he's looking like he's going for a modest, small apartment. You know, sounds like it would fall into the category of necessaries, and certainly getting tooth fillings replaced, unless he's having them replaced with gold or something exotic like that, these are going to fit into the category of necessaries. But we don't live in that world of voidable contracts. We're talking about void contracts. So this contract would be void even though it's for a necessary, because again, the state is already providing for his housing. He doesn't need any housing, not until he leaves. Similarly, the state is supposed to provide for his dental hygiene needs. So both of these contracts are going to be void. This second contract isn't maybe for a necessary. Certainly people don't need vintage Mercedes, but you could argue in certain parts of the country that you do need a car to get around. Maybe there isn't sufficient mass transit available. So you might be able to argue that it's a necessary, but whether it is a necessary or not, it's clearly going to be a void contract. Now, can Brad, the bank robber, buy these things the day that he gets out of prison? Absolutely. I mean, obviously, he can't use his ill-gotten gains, but if he somehow or another manages to earn the money in a legitimate way, he can absolutely rent a small apartment. He can absolutely buy that vintage Mercedes, and he can absolutely arrange to get his dental work done. Once he's released from prison, he immediately has those rights, but until he does, he can't do any of these tasks. So hopefully that clarifies that issue just a bit. Let's go back to our initial slide, and I think we've covered all of our categories. We've now covered that a person has to be an adult by law, has to be legally sane, has to be sober, sometimes has to be a legal resident, and can't be currently incarcerated felon. So we have a little table here that kind of summarizes what we've been talking about, and hopefully this will be useful. There's only two categories here that we have void, so let me point those out to you because this can be a source of a little bit of confusion, what's void and what's voidable. So the only times that we have void situations are when the court has declared someone mentally incapacitated. This is this non compos mentis that we talked about in our first lecture. And the second is that a person is incarcerated. You can see in both cases it's a cut and dried situation. We just know because there's a court record, and the assumption is everybody knows about a court record. Well, there's certainly a court record about somebody's incarceration. So you can see there is a commonality between these. So there's unambiguous court records exist about both of these facts. The voidable ones are things that we typically don't have that kind of for sure, absolutely certain record. Under 18 and non-emancipated. Incompetent but no court declaration. This person is a resident or citizen of a country that is at war with the U.S., a highly intoxicated person, but again, there's no court order about it. And so you can see there's a little bit of doubt about some of these situations. So as you're sorting through them, be sure to know the difference between void and voidable. There will be some test questions, or at least one test question that I can think of right off the top of my head on this topic. So be able to sort through it. And again, the best way of doing it is to be understanding why there's a distinction there. Don't just memorize the list. That's hard. Think about the reasons why there's the difference in treatment and the law. Okay, so let's talk a little bit about practical application here. These are terms that are kind of related to the topic of capacity. Specifically, we'll see an affidavit typically asks the same types of questions that we've been asking, and so we'll look at those in a second. So this is kind of relevant, not completely on point, as our textbook likes to do, is likes to broaden our horizons with vocabulary that isn't always 100% on the mark. What is an affidavit? Well, this is an example of one. It's a very, very common thing to work on in a law firm, and very commonly the paralegal will interview the potential witness, will prepare a draft affidavit, and will oftentimes be a notary, and will actually notarize the document. So let's see what an affidavit is. Any voluntary statement reduced to writing, so it has to be in writing, and is sworn to before a person legally authorized to administer an oath or affirmation, and typically this is going to be a notary. Doesn't have to be. There's other people it can be, but I'd say 95 times out of 100 or higher, it's going to be a notary, which is oftentimes the paralegal. It's basically, at the end of the day, a sworn statement. The person who swears it is the affiant. So what do we use affidavits for? I mean, there's lots of things we use them for, but one category are going to be pleadings. And actually, this isn't that common that we use it for pleadings. Some small category of pleadings do require that we have a sworn affidavit associated with it. That's not the usual rule, though. Most of the time, a pleading isn't going to have any affidavits at all. But here's a little refresher about what a pleading is. It's a formal statement contained within a legal document by the parties to an action setting forth their claims or defenses. And then, of course, the initial pleading is the complaint. This is what we call the first document filed in federal court. Of course, our name for this in state court is petition. But it's the same thing. So what is a complaint? The initial filing in a federal civil action in which the plaintiff alleges one or more causes of action and asks that the alleged wrong be remedied, sorry, typo here, by the court. So we also have an answer. The answer is the other big pleading. That's, of course, something filed by the defendant in response to the complaint or to the petition. In other words, it answers the complaint or the petition. Probably more commonly, an affidavit is attached to a motion. So let's talk a little bit more about motions. A motion is an application made to a court for the purpose of obtaining an order or rule directing something to be done in favor of the applicant. Motions may be written or oral depending upon the type of relief sought in the court in which they are made. More commonly, they're written, and obviously if they're going to have an affidavit associated with it, they really do need to be written. So this would be something that you would reference. You might, in order to say that you're entitled to a certain type of relief or a certain type of decision, you might enclose an affidavit. For example, let's say that the attorney wants to make sure that a trial is not scheduled for the third week in July because the attorney is having a surgery during that week. Well, the attorney might attach an affidavit that states, he's planning on having surgery on this date, and this is the procedure, and these are the dates of the surgery, and this is what the doctor has told him in terms of his period of recovery. And so that is his way of saying, hey, I'm not kidding here, I mean it. I guess he could, if it were highly contentious, even get an affidavit from the doctor to demonstrate, hey, yeah, this is legit, this is what's going to happen, this is why it needs to be at this time. And so that would be an example of an affidavit that you might have associated with the motion. I mean, there's a million different scenarios that you could have it. That's just one. So let's look at some of the things that we're typically going to have in an affidavit. And this is really why the textbook author has decided to discuss this topic at this point. One is that oftentimes there's going to be language in the affidavit that says that the affiant has reached the age of majority. Again, nowadays that's going to be 18. You not infrequently still see affidavits that talk about the age 21 being the threshold, because that used to be the rule, say back in the 40s or 50s, where you really did have to be 21 before you were considered legally an adult, legally considered able to fully understand the oath process. As a result, sometimes attorneys are a little bit on the conservative side, and if the person is already 21, why not just stick with 21? Obviously, if a person is between 18 and 21, then you'd want to tweak the language so we say 18 instead of 21. So that's one thing you want to list. Another thing that's oftentimes listed is that the person is of sound mind and oftentimes also sound body, if that happens to be the case. Again, this is going back to the fact that if you're insane, you may not understand the oath process, and so you want to confirm that. And then occasionally you'll even see language that says the person has not been convicted of a crime. This is not so much because of the incarcerated felon rule, but it's more to give the reader the impression that this person is trustworthy. Hey, they haven't been convicted of a crime. They're probably telling us the truth if they're putting something under oath. So these requirements really have nothing to do with creating a contract, but have to do with, is this person's testimony credible? And again, the same issues that we look at to decide whether someone has the ability to contract are some of the same issues we also consider when we try to decide whether a person has the judgment, the maturity, the understanding to make a sworn statement. So here's an example of language. There's nothing magical about this, but this might be the language that you might see at the beginning of an affidavit. I am over the age of 18, am a resident of Collin County, Texas, have personal knowledge of the facts contained in this affidavit and suffer no legal disabilities. I actually didn't include anything about not being convicted of a crime, but you could easily imagine that being included in here. I just stuck a picture of a jurat in here. This is what it goes at the bottom of an affidavit that the notary actually completes. For the notary would sign here would indicate when his or her commission ends, and it's the statement that the statement is, or the notary's a part that explains that the statement is under oath. Here's an example of what you might see sometimes an affidavit looking like. They don't always have the style of a case. For one thing, many times affidavits are done without any particular case being referenced. You can see this one is for a state court in New Mexico, so the style is different than what we see, but we can see in some respects it looks like our style. And then we have an affidavit. It's, again, we don't have to have any of this, so if we weren't, even if we were preparing the affidavit for a particular court case, it's not unusual for people to choose not to include this on here. But there's nothing wrong if they chose to include it on here. Obviously, we wouldn't include this on here if we didn't have a lawsuit. So we might start right here, affidavit of whomever this is. You are typically going to list the state and the county where the affidavit is being entered. And you start with something like this. Richard Offshee, PhD, first being duly sworn, states, and we can see his statements. I am of sound mind at more than 18 years old. So we have the two things that we were talking about before, and then we're going to go through kind of his life story. I don't think I included the rest of the affidavit, but eventually at the end of it, we'll have something like a jurat. Here's another affidavit. Again, this one doesn't have a style of a case. We just start with the state of Illinois, county of Cook. And again, we have a title, Affidavit of Emily Winter. Now we have a topic. You don't have to have a topic, but if you have a lot of affidavits in a case, it can help the readers make sense of it. This one's concerning a lost or missing tooth. We have affiant, so we know this is the person who's going to be signing, and you can see, well, yes, here's her signature. Down here says she is the affiant. Emily Winter being first duly sworn, so we can see this is kind of boilerplate. We saw this also on Richard's. States as follows. Affiant, this is a little different because we can see when Richard is talking, he's talking in the first person. I am of sound mind. I hold a PhD. I am presently. But when we have Emily, we have it in the third person. Both you will see from time to time. The first person I think is more preferred, at least in our part of the country, but this works too. So we have affiant as a resident of the city of Chicago, county of Cook, and state of Illinois. Missing that final comma there. On the morning of November 30th, 1989, at approximately 7:45 a.m., affiant became aware that she had lost her bottom right front tooth. After making a diligent search for the aforementioned tooth, including a close inspection of her bowl of alphabet cereal, affiant was unable to locate the missing tooth. This affidavit is given for the purposes of inducing the tooth fairy to compensate affiant in the usual and customary manner for the aforementioned lost or missing tooth. Affiant further states that if so compensated, she shall not seek additional compensation if the tooth is located in the future. And here is little Emily's signature. Of course, we have a problem here. Probably Emily is of reasonably sound mind, but I don't think she's really 18. And you may have noticed that language was missing from this affidavit. And here is the jurat. I'm guessing little Emily's dad is a notary. And so he was able to execute this for her. A little fun thing. Of course, as always, if you have questions about this material, please don't hesitate to send me an email, or even better, come by my office hours and we'll talk about whatever is on your mind. Hopefully this has answered any questions that you have about legal capacity, our third of our 4 elements for contracts. And hopefully it has whet your appetite for our 4th and final element, which we'll be covering in the next chapter. Of course, that topic is legal object or legality. Thanks for your attention and have a wonderful day.